How are you? Good. So, I saw the claims report. Okay, so, but it doesn't. Are you intending to?
I tried to pause it. You could hear a little bit.
Yeah, that's what the point that I was saying. Judgment in addition to other issues. That
Sure.
And so I would propose that this were, she asked me that. You should request this before the following. I'm gonna get that, because these people here and she can decide whether or not.
Yeah.
So it's not that she goes for it at all. I think it's really.
I'm gonna say,
equivalent.
I'm gonna say today, my intention when I told the judges that I have full acknowledgement, I was intending to follow the distribution plan today, but I didn't, because I got busy and it's a big document and I'm working on it, I'm getting close. So I'm gonna tell, right, yeah. I'm gonna tell her on the record today that that's gonna happen in the next 30 minutes. And my intention is to get it done soon.
And with respect to the letters and those lawsuits and my motion to the when do you anticipate that kind of stuff happening?
Your own judgment. Because that's the only basis for collateral attack. That will be done. Just also within the next 30 days. I'll visit with you about it.
Okay. All right. So I guess we're sort of reading the procedural framework. Your intention is only to do you have the forensic analysis ready? Do you know?
Let's have it after today.
Do you have anything about this?
I think his contention is from the
Okay.
Stay tuned.
Okay. Thanks.
This, we call the case the Pride of Austin receivership case. Let me take attorney announcements, who will be talking. Let's do that first. Attorney announcements and who you represent for the record.
Morning. Good morning, Your Honor. Trip Nix for the receiver, Greg Milligan.
Thank you.
Your Honor, I'm Kent Anschutz, individual attorney investor. And with the court's permission, I'd like to make a few comments.
Hold on, we'll do that. We
Okay.
can in a minute, but let's just do announcements first
Sure.
and we'll come back to you. Yes, ma'am.
Hi, Isabel Anton-Georgi. I'm here on behalf of the trustee of the Tovia 2013 revocable TRS, the Amish Talia IRA account, the Patricia Lloyd Jones individually and as independent executor of the estate of James L. Lloyd, and on behalf of the James L. Lloyd IRA and the James Lloyd Roth IRA, John Arizbe, Judy Arizbe, Richard Gardner, Lorena Gardner, and Jeffrey Walton.
Thank you. Anybody else want to make an announcement? You don't have to. I see some other people in the room. Go ahead.
Good morning, Evan Johnston for Mary Ellen Canty, Your Honor.
Thank you. So I also see the attorney for Mr. Buchanan in the room. She does not, I don't think, intend to speak this morning, but that she is here as well. That's Ms. Friel. All right. We have a few things, mostly the review status. But let's see where we are. Let me let Mr. Nix go first to just tell me kind of the business before the court today. And then Mr. Anschutz, I'll turn it over to you. Go ahead.
Thank you, Judge. So two things that we want to do today. First of all, just go over a general status report like I've done previously. And then second of all,
Hold on 1 second. Remember, I don't want no cell phones, no playing of cell phones, no using cell phones to record. Let's keep everything on silent. This really isn't a courtroom where I throw people out for things, but if we see a lot of like cell phone use and it distracts us, we got to ask people to leave. Thanks. Okay, go ahead.
so gonna give just a general status report like I've done in the past. And then we've talked about for the last few times that that the receiver's financial advisor was preparing a forensic report. He's here today and that's done. And after we get done with this, I would just turn it over to him to present it if the court is okay with that.
All right, thank you. And then let's hear. All right, go ahead.
Judge, just with your permission, I wanted to make a few comments on behalf of myself and many of the other investors that are
Well,
not parties.
You can't, unless you're their lawyer, you
I
can't
am.
you are their lawyer.
No, I am.
You're a lawyer.
Yes.
No, I know. I meant, but you need to be careful
No.
because you just said, I'm going to make a statement on behalf of myself and the other investors. And so I want to be clear that you only represent you.
That is correct. Others have contacted me, but I don't
But
represent.
you don't, yes. So that's the only thing I was saying is I wanted to make that clarifying point for the record.
No problem.
You believe, based on your conversations with people who are in a similar circumstance with you, that they would also share these concerns that you're about to say to the court, but you are not saying you represent them.
Absolutely. Your Honor.
Now proceed.
Okay, thank you. Your Honor, we are now at about 1 year into this proceeding. And although waiting patiently and appreciative of the work the receiver has done so far, there continues to be one glaring omission. So far, we have not heard one word, one peep about the assets of the defendant in this case, Robert Buchanan. Now, he is the entire reason we are here. He is the entire reason for this disaster. I might remind the court that for at least a couple of years, he obfuscated, he delayed, he bald-faced lied to investors about the status of this fund and their investments. He did the same to the receiver at the beginning of these proceedings. Now, the fund purportedly originally had $60 million of investor funds. Now, as the court has seen, it has a few derelict buildings. Most of the investors, I can assure you, believe that this money did not just disappear, but that it was funneled to the defendant and his family members who were purported employees and directors of the fund. Now, as the court has noted before, your powers are somewhat limited in an action like this, but the receiver, through his attorney, has the mighty power of the subpoena and the tools of civil discovery. Now, the vast majority of us investors, and many of us who actually had our own lawsuits pending, we were dragged into this receivership, not necessarily willingly. But we understand why the court decided it was the best interest to do this. But I can assure you that those of us who had lawsuits pending would be utilizing every discovery tool, all the subpoena power, and the defendant would have worn through several seats of pants by now, sitting in that witness stand being grilled by many lawyers. Now, as we are now part of the receivership, we have to look to the receiver and to you for relief. So I'm basically asking that the court light a fire into the receiver. Now, I hope this forensic report is going to shed light on what I'm talking about. I'm not confident that it will, but I'm asking that the court basically require the receiver to utilize every tool that exists in the civil rules procedure to discover and recover funds that investor funds that we firmly believe were funneled to the defendant and his family members. Thank you.
Thank you. Let me ask Mr. Nix, I mean, have you taken Mr. Buchanan's deposition? And if not, why not?
We have not taken his deposition. We've had interviews with him related to what assets he has with him and his counsel.
Do you record those interviews or are they informal interviews?
The interview we had was not recorded. We have had statements submitted, bankruptcy schedules that detail assets of.
So is he in bankruptcy?
No, we asked that they are a good tool to show what assets exist. And so we said, fill those out. They were filled out. So you'll see today in the forensic report where a lot of where we think the money went. What Mr. Milligan is trying to do is spend dollars in the highest and best way to maximize recoveries. And so,
Well, I have said, and I'm going to just interrupt you a little bit. I have said, I don't believe, it's unfortunate to me, I'll just state this, that the regulatory agencies for the state of Texas have not gotten involved in this. But I have a limited power and a limited funds here. Unfortunately, the funds are the receivership funds. I don't know if they are involved or not involved. I've learned a lot about receiverships in the last few years. I do not believe they are the best way to do this. I think in both of the cases that I have them on, though, they're the only way that anyone has done anything in this. I'm with you. I'd like to do it, Mr. Amstutz, but we also got to get all the estate settled first. And once we start doing what you're talking about, and I totally understand, there's not going to be any money left because the things that you talk about take a lot of money and they take a lot of time, and civil discovery is wildly expensive. It's just a wildly expensive process. And if we do that, we're going to not be doing this. I hear what you're saying. You want your 5 pounds of flesh and maybe you deserve it. We're going to get, I guess, at some point in this long process, what Mr. Buchanan did with the money. Maybe we'll get a little insight on that today and whether Mr. Buchanan should face some sort of penalty for that. But this is a civil court. There are limited powers that a civil court has. And I appreciate what Mr. Nix is trying to say, even though I interrupted him. He's trying to keep his eye on the ball of trying to do the job of recovering assets, I think, for the receivership estate, along with the receiver. But once we open the floodgates of litigation and constant civil discovery to go after Mr. Buchanan, not saying he doesn't deserve it, but right now that would take money. I don't even know that I could approve it because it would take so much money out of the estate to start that process. I mean, I'm asking you, like, what, you know that you're a lawyer and that is an expensive, time consuming, often unsatisfying process, civil discovery.
Well, I guess my only response, Your Honor, is there's been a year to be doing that simultaneous process along with dealing with all these little trees.
So you want them to do that. Your proposal would be they should be doing that simultaneously.
Absolutely.
They should be, but you understand that works maybe against your interests. Like it could deplete the resources that are in the estate.
Well, every hour that everyone in here but me is sitting here is depleting the estate. I mean,
That's correct. But this one depletes the estate to what end, though? I mean, if there isn't, we're going to hear today what the story is from Mr. Milligan about what he found. And sometimes people are really bad with money. I don't know what happened here or didn't happen here. I will tell you, I'm a family court judge as well. And in most family court cases, the spouse who is not in charge of the money believes there's a lot more money than there is. That's just the story of family court. Somebody has built a house of cards with regard to money. That other person is living in that same house of cards. And when the house of cards come down, one person says there's no money. The other person always believes that that person has squirreled the assets away, that they have put the money in 8 or 9 accounts. In the civil process of discovery, not always, but 90% of the time, chases down those threads and finds that in fact, no, they were just really, really bad with money and there's not a lot of money to be had. So I don't know what we have here. Maybe we'll get some more insight from Mr. Milligan today about what we can do with this, and what there might be in terms of eventual actions against Mr. Buchanan that would result in some sort of money and assets in the estate for the people to recover. But I don't know if we're going to find that or not. We're just going to have to see. But I do think they've done a pretty good job of balancing kind of, let's get everything we can get. It's taken longer than you'd like, of course. It's taken longer than any of us would like. Civil court takes a while. It just is a slow slog. But, you know, eye on the prize, I think at this moment, we're just trying to recover what we can. Go ahead, Mr. Nix.
2 things. One, I think that the highest and best potential for recovery of dollars is the stuff that I'm going to talk to you about today, which is recovering of the collecting on the loans, selling the assets that we have, and we've made, I think, tremendous progress on that front.
What do you think about Mr. Buchanan? Does he have a lot of? Is your receiver going to talk about anything that he might have personally today?
So, 2 things. One, we went through this process where we got the bankruptcy schedules submitted under penalty of perjury, all of the rest, and it was Mr. Milligan's determination that it wasn't a good use of funds to spend a bunch of dollars on lawyers to go and get a judgment against him. However, he is in the process of trying to retain potential contingency fee counsel that could do that on a no cost basis to the estate.
When he's going to explain this to me, maybe you'll ask him, but not a good use of receivership funds because there's nothing there, or not a good use of receivership funds because it's just going to be a very difficult kind of time-consuming process, and that'd be a better thing to do with a contingent fee lawyer rather than your time.
I think it's the former.
Okay.
And there.
So we think there might be things there.
I said the former. So yeah. I mean,
former.
If some of the stuff that we've had to do to try to collect money has been incredibly time consuming and difficult over lots of objections, so on and so forth.
Right.
But there's money at the end of the rainbow, which I'm going to talk about. And that's what the receiver has been spending.
And but that's things the receiver already has, is all these receivership assets that were owned by the fund that we've been doing all these bankruptcy actions.
Yeah, or loans that we're trying to collect, which the borrowers don't want us to collect.
You've been in bankruptcy court. We got a long story of that
Yes.
because you have to go to all these different places and do it. I understand that. I just, well, let me ask you a question then. If there's not a lot of assets to be had from Mr. Buchanan personally, why would the court approve even a I guess, because why not? If there's a contingent fee lawyer to wish to take the case. I mean, if there's nothing there, why would we do it?
Well, I mean, if some contingency fee lawyer wants to take a flyer on it and thinks that there's the ability to collect money there and they're willing to invest their time into it, then that there seems to be no downside for the estate.
Okay. No, that's true. He thinks he might be able to find that.
I don't know.
We'll see. But his investigation so far has not, you haven't believed it's worth your time so far to spend those efforts.
That's right.
Okay. I mean, I don't know what to say.
Judge,
I mean, it's a really hard situation. Like, I'm frustrated by this case. Y'all are frustrated by this case. We're all very frustrated, I think, because, I mean, Mr. Buchanan, I don't know what the plan here was, but it clearly, whether, whatever it was inside of his head while he was doing this, it was not a good plan. It was either, clearly, I just don't find this to have been a well-run yield fund. It just wasn't.
Judge, I don't want to, on the record, I'm not meant to
Yeah.
belittle anything the receiver's done so far. I couldn't do their job in diving after all the minutia of all these properties.
Right, I couldn't either, I mean, clearly, but this, I mean, let's just state the obvious here. This was not a good fund. I mean, he did not do good work. Like, that is, I mean, I'm just gonna be honest with you, that's what I have seen. Now, whether he was, they're doing a great job, frankly, in a not so great market, trying to get what they can get. But I just think the investors are gonna have to recognize, I just don't know that in this current market, in the year 2025, what the plan was, maybe was, we're gonna do a bunch of land deals in these kind of strange places and strange land deals, and we're gonna make a lot of money because land in the state of Texas is, property in the state of Texas is always going up, and perhaps that's true to a little bit of an extent, but this, whatever the plan was, clearly the market hasn't helped with that plan. I'm just gonna be honest with what I see.
Well, that's true, but just to remind the court,
Uh-huh.
there's a track record of at least 2 years or more of investors approaching Buchanan, asking for updates, asking to look at records, asking how is the fund, and being bald-faced lied to repeatedly over and
Yeah,
over and
well,
over. And
A fair bit of that as well. I didn't mean to discount the fact that perhaps there were,
And I think where there's smoke, there's a fire, and that's why we firmly believe.
well, sure,
many
there's a
others went-
fire. I guess that's my thing, but okay, so let's say he had bad motives and he was lying to you all and he was taking your money and living off of it, or what are these other things? But that doesn't necessarily mean there's money for y'all. I mean, it just means he was
Well, my whole point is,
allegedly doing bad things. It just doesn't mean there's money. It just means there was bad motive.
my whole point was for the court to encourage the folks over here to at least find that out as to the best of their
Yeah.
ability.
I understand. I just finding that out and chasing that story, it almost works against the investor's interests on some level, because it's meaning if there's no money at the end of the rainbow, then you can chase and you can discover that he did all these bad, terrible things, but it's not going to put money in your pocket. Versus I think what they've been trying to do, and yes, it's an expensive, time-consuming process, and they're getting paid for it, but I really do think they've tried to keep their eye on the ball of recovering what needs to be recovered. And maybe I'm being naive, but I really think that is what they have been doing. They've been trying to do it in a respectful way, because this is the process we have. And that just feels like what we've been trying to do. Now, you're right. We might turn the page and go after Mr. Buchanan a little more for bad deeds if those in fact happened. But I don't know that I'm going to fault them too much for not doing that right now.
Well, I think the contingency lawyer is a great idea
Okay.
and would encourage that.
All right. Well, thank you.
Thank you.
So where do you want to go next?
The plan is for me to give my regular status update.
Great.
And then go from there. Can I share my screen?
Let me remember. I have to think about how you do it. So are you hooked up to the system or no?
I've got it plugged in.
Then yes, then I do it. You go off screen, but I want you to know that your screen will be broadcast on the YouTube broadcast.
That's fine.
Okay, then here we go.
Okay, so this status report is gonna follow the format that I've done previously, which is I want to talk about where we are in terms of collecting money against the various borrowers of Pride of Austin. And then I also want to talk about the REO properties, meaning the properties that the fund owns. A lot of that is kind of melded together because we've gotten properties back as a result of foreclosures, deeds in lieu of foreclosure, things like that. But I'm still going to keep that general structure. And then I want to talk about the claims process, distribution plan, some potential litigation against net winners in the fund, and various tax issues. So start with the loan portfolio. The borrower, first borrower I want to talk about is called Milan Sai. This is the borrower that we spent the most time on since we last spoke. This borrower, you'll recall, has the Super 8 motel in West Texas. The principal value of the loan was $2.3 million. That loan matured at the end of 2020, and between the maturity date and and really the beginning of 2024, there was really no activity to collect the loan. And so while the principal balance was $2.3 million, after maturity through 2024, it was accruing interest at the default rate. So the actual balance skyrocketed. And the claim that the fund has against this entity is now $3.9 million. A good portion of that is default rate interest. The receiver sued Milan Sai and its two guarantors in August in this court. And then ultimately we posted the real property for a foreclosure sale for November 5th. On November the 4th, Milan Sai filed a bankruptcy to stop the foreclosure sale. Now, the value of the hotel is worth less, substantially less, than the principal balance of the loan even. And so on the debtor's bankruptcy schedules, whenever they filed their bankruptcy case, they listed the value of it as 1.6. And I think that the taxing authority in Martin County has it at substantially less than that, even maybe 1 million. The Milan Sai filed the bankruptcy case as a subchapter 5 debtor, which means that it's a small business debtor. And a small business debtor has a much easier road in a bankruptcy case. They could have altered the fund's rights materially over our objection in a small business case. And so we objected to that designation because our contention was that the debt that they had was too significant to qualify as a subchapter 5 debtor. So we objected to that. And then we also filed a motion to lift the stay, meaning that we could continue to proceed with the foreclosure. We went and had a hearing in the bankruptcy court on this. At the hearing, the debtor agreed that it would withdraw its election to be a small business debtor, which means that the receiver effectively has a veto right over any plan that they would have to escape bankruptcy. And so the receiver would have to consent to whatever treatment that this debtor wanted to do to it in a bankruptcy case now that it's not a small business debtor. So that was material. And then the debtor also agreed that that the stay would automatically lift at the end of April if it didn't have a plan confirmed. And in the interim, they were going to pay the receiver about $15,000 a month. So far, all of those payments have been made. So because the value of the collateral is worth less than the debt, the only way that the receiver was going to be able to collect additional dollars for the fund was through pursuit of the guarantors. And we have continued to pursue the guarantors during the pendency of the bankruptcy. So the lawsuit that we filed initially had Milan Sai, the debtor, and the two guarantors as defendants. And since Milan Sai filed bankruptcy, that case was stayed. And so we filed a motion to sever the guarantors out from that case because there is no stay that protects them. We brought that to the court. It was objected to by the guarantors, if the court recalls, and the court ultimately granted that motion. And so there was a new case that was created as just against the guarantors. We then filed a motion for summary judgment in that case and set that for hearing. After we filed the summary judgment motion, the guarantors went to the bankruptcy court and asked the bankruptcy court to extend the automatic stay as to them, effectively meaning that they were asking the bankruptcy court to enjoin the receiver from being able to proceed with its litigation in this court. We objected to that, of course, and had a hearing on that in the bankruptcy court, which we won. And so the stay did not extend to the guarantors, and we were free to continue pursuing our litigation against them. So on the first day of April, we had a mediation with all of the various parties, the debtor, the guarantors, and the receiver. We mediated with Judge Hale, who's a former bankruptcy judge in Dallas. And ultimately, we reached an agreement with the Milan Sai and the guarantors, and the agreement is this. The guarantors are going to have to give the receiver an agreed judgment of $3 million. They have to pay the receiver $3 million by January the 8th, and they have to give 100,000 of that down by May 8th. And they're subject to certain credits. So the sooner they pay, the less the amount is. But in no instance will it be less than the principal amount of the loan. And additionally, they're going to run a sale process in the bankruptcy case. So we're going to have a court supervised sale process of the hotel. And that's going to, the receiver has the ability to credit bid if he wants, and take back the property. But if there's another bidder and there's cash, then there could be a sale of it, and all of those proceeds would then go to apply to the balance that's owed to the fund. So we think that was a good outcome, and that was where we spent a lot of time since we've last been here, was at Malonsai. The next borrower, Your Honor, is Trinity Consulting and Construction. This is the home builder in Lago Vista. They have 6 lots that served as the fund's collateral. 2 of those lots had improvements on them. One of them was a home that was probably close to 90% complete, around there. And the receiver wanted the home builder to finish that home and then sell it in an effort to get the highest and best price. But the home builder just didn't live up to its end of the bargain on a number of occasions. And so the receiver lost faith in the home builder and posted the properties for foreclosure in March. We had a foreclosure sale and took back the properties. So the receiver is now in control of all of the Trinity, is the record owner of all of the Trinity collateral, and has hired DWM Construction to finish the remaining 10% or so of the almost completed house. That will get sold, and then once there's a contract, of course, we'll come to the court. Similarly, he's going to list all of the lots for sale as well. But we now have got title to those properties, which is, a good development.
Good work.
Guestweiser is the next borrower. So this is the borrower that had real property in Dallas, plus these modular housing units. That's the collateral. It's not in a very good neighborhood, and it's not in very good shape. But the 2 pieces of collateral are the real property plus these modular housing units. The modular housing units were in another state, and the receiver decided that it was the best course of action was to try to get back both of these pieces of collateral. And we tried. We were going after them starting probably in the middle of last summer, and they obstructed significantly. They filed a lawsuit against the receivership estate and got a TRO that stopped the foreclosure from happening. That case was ultimately dismissed. It was violative of the receivership injunctions. And then after that, we posted it again for a foreclosure. They filed a bankruptcy case. That was ultimately dismissed. And so finally,
You had to work in that, right? You
Yes.
had to actually file something and be involved because you were the ones who were helping that bankruptcy judge know.
that's
dismiss
right.
the
We
case.
filed a motion to dismiss or to lift the stay. I don't remember what
Right,
it
I
was.
can't remember, but yes, you were following all this and having to deal with each of these efforts to thwart the
That's right.
receivership in many ways.
And they filed a lawsuit in Dallas
Right.
and got a TRO. And we filed a motion in this court to enforce the receivership injunctions and got that separate hearing. And then they dismissed the case after that, instead of having that hearing. And then they filed the bankruptcy. So we had a clean shot at foreclosure in December. And on the day of the foreclosure, they proposed something that the receiver thought was worthwhile, which was they were going to execute a deed in lieu of foreclosure to the receiver that we would hold in escrow. They would pay the receiver $45,000 down, and then they were going to pay another $655,000 by February the 3rd. And if they made that payment, then the receiver would release its lien on the real estate, and they were going to allow us to foreclose on the modular units and sell the modular units. They made the $45,000 payment. They didn't make the $655,000 payment, and so we recorded the deed in lieu and took ownership to the real property. We also foreclosed on the modular housing units. The court will recall that I think it was last month, we came into the court and asked for approval of a sale of the modular units. And there's not a large market for purchasers in these for this type of asset. But Mr. Milligan found one, and those were sold in February for $422,500. It was done in a seller financing, so the receiver took a note back from the purchaser, which is due in August. It's going to accrue at 8% interest. And there's 5 of these modular units. Every time one is sold, the deal is that the purchaser has to pay Mr. Milligan, the receivership estate, $84,500. And then there's interest on top of that. And then additionally, he's marketing the real property and several interested parties, I think even a couple of offers. And we anticipate that we'll have that under contract next month, and we'll come to the court on that as well. Valor Club is another borrower. this is the borrower that has real property in San Antonio. It's like 50 acres on the northwest side, I believe, of San Antonio. We went through it with these guys, posted it for a foreclosure, and they were about to file bankruptcy and came to a deal that we thought was worthwhile, which was they were going to give us a deed in lieu of foreclosure, which they did. They were going to pay the receivership estate $150,000 in November, which they did. And then they were going to pay the receivership estate another $4,050,000 by the end of January. They had the option to extend that maturity date 2 times for up to 30 days by paying $50,000 to the receivership estate, and that money would be applied to the balance. So they did that on both occasions. So the receivership estate got another $100,000. And then it was up at the end of March. They reached out to us at the end of March and said that they were very close on a refinance, asked for an additional 30 days and to pay an additional $50,000 for that to get the 30 days. We ultimately agreed to that, but said that they had to pay us the $50,000. Only $25,000 of it would be applied to the outstanding balance. The other 25 would not be. So effectively, it just made the settlement $4,225,000 as opposed to $4,200,000. So we're hopeful that money's going to come in, but in the meantime, we have collected $300,000 on account of that loan. And if they don't, then we have the ability to, if they default, we still have the ability to record our deed in lieu and take ownership of the property and then sell it. Final borrower is Hidden Oaks at Berry Creek. This is a borrower that's got 3 undeveloped lots in Williamson County. Receiver's been letting the borrower market the property. But there's been no material movement, and so the receiver is plans to foreclose on those in June and pursue the guarantor for the deficiency. So just as a sort of a summary of the collection activities with Milan Sai, we have an agreement that they're going to pay $3 million. We have a court supervised sale process in the bankruptcy court with protections for the receiver. With Trinity, we now have title to all of the real property and can go sell it. With Guestweiser, we now have title to that real property and can sell it. And we have sold the modular units for $422,500 with seller finance. With Valor Club, we've collected $300,000 to date and are supposed to receive another $3,925,000 by the end of April. And then with Hidden Oaks at Berry Creek, there's going to be a foreclosure that we anticipate we'll get title back to that in the next month or so, and then pursuit of the guarantors. So that's where we are on the collection activities. If the court has any questions, happy to.
I do not on that.
So the REO properties are, these are the properties that were owned by the receivership estate whenever Mr. Milligan took over. At least the first 3 were. The other property is the one that was Mr. Buchanan's residence that was foreclosed on or a deed in lieu of foreclosure actually, and then sold. Net proceeds of that one were $1.4 million. Those are in the receiver's account. The Canton property is the one out in East Texas that was sold. Net proceeds of $700,000 thereabouts in the receiver's account. The Fulcher property was an REO property that was in the receivership estate whenever Mr. Milligan took over. Mr. Milligan's gotten a number of offers on the Fulcher property. It's listed for sale, and there's a letter of intent that's being negotiated as we speak. And we anticipate that there's going to be a sale that we'll bring in front of the court in the next little while that will be a sale price in excess of $2.5 million. And then the Overcut property was a property that was owned by the fund when Mr. Milligan took over. It's a house in South Austin that was under construction. House was still in the process of construction. There was an accessory dwelling unit, an ADU, accompanying it, and but it wasn't finished. So Mr. Milligan hired a contractor to finish it, and that is what we understand will be done by the contractor by April 30th. There's some piece of there's some approval that's needed from the city for like a right of way or something along those lines that is not in our control. But once that is done, then it'll be ready to sell, which the receiver will put on the market and hopefully be back in front of the court on a motion to sell that relatively soon. So those are the assets that Mr. Milligan has been going after and trying to collect and bring dollars into the estate. Any questions that the court has?
At this point, still no.
Okay. So just a few more things. First of all, I want to talk about where we are in the claims process and the distribution plan. Court will recall that we filed a motion for to establish a claims procedure, which was approved. The claims procedure bifurcated the claims into investor claims and creditor claims. That was approved on June the 17th. As part of the investor claims process, we had to send out reconciliation notices. The reconciliation notices contained a transaction history for all of the various investors, and it would show the money that was put into the fund by the investor, the money that was paid from the fund to the investor, and then the amount of any reinvested dividends. And so that was sent out to each investor. They had the ability to object to that transaction history if there was an inaccuracy in it. They had to do that by August the 23rd. We received 32 objections. By the 12th, which was a hearing on the unresolved ones, all of them had been resolved either by being withdrawn or entering into some sort of a Rule 11 agreement with the various investors. So that process is substantially, it is complete. Then there was creditor claims. The creditor claims process, the creditors had until October the 15th to file, that was the bar date to file creditor claims. There was a claim form that was approved, and they had to submit them to the receiver's claims agent. And then the receiver had the obligation to file a claims report, and the claims report listed out the receiver's recommendation as to the allowability and amount and priority of the claims. Receiver did that, filed that report on January the 20th. Anybody that had an objection to their treatment was required to file a objection by February the 3rd. We didn't get any objections, and that's with one exception, which is that the court knows that there's these various investors that got judgments before the receivership, and they filed creditor claims. The receiver has a different view on how those claims should be treated, so they're going to be, we anticipate, are going to be objecting to the distribution plan, and they would have objections to the claims report as well. But in consultation with the lawyers that are representing them, we agreed that it would be most efficient to just basically hold those objections until the distribution plan was filed. And so those folks, represented by Ms. Anton-Georgi and Mr. Dunham, as well as Mr. Mercer, two separate groups, we entered into this Rule 11 with them that effectively extended their deadline on the claims report until after the distribution plan is filed. Distribution plan. So under the claims order, we're required to file a distribution plan that says, the amount, method of distributions and the priority for the various stakeholders. My intention was to get that distribution plan filed like before today, but it just hasn't worked out that way. And so, but putting it on the record, we will get that filed within the next 30 days. There's not a deadline in the claims order or anything, but just in the interest of moving this along, it's a priority item that will get filed soon. Net winners litigation. So there's what the receiver has determined is that folks that got profits on their investment, meaning dollars over and above their principal investment, that those were not really profits, but were instead a redistribution of other investors' principal. And so the receiver's got a fiduciary duty to maximize recoveries, ensure a fair distribution. And so there's going to be litigation against some of those net winners to recover payments that were received by them in excess of their principal. And so, even though it was likely unknowing that they received this money, they were profiting on the net loser's expense. And so recovering those funds and then redistributing them appropriately is in the interest of equity. And then tax matters. So I know that there was a number of folks that had questions and wanted to get a fair market valuation of their interest in the fund, which I think is something that had happened prior to the receivership. And my understanding is that they needed it for their IRA custodians. So Mr. Milligan has tax advisors at Weaver and Tidwell, and we had intended to get a fair market valuation to those folks. But after a number of communications and back and forth with the tax advisors, they ultimately told us that it would be impossible to come up with a fair market valuation of each of these individual investors' interest in the fund because it's contingent on so many things: how much dollars come in, what the distribution plan looks like, et cetera. And so Mr. Milligan prepared a letter that explained that, and we posted it on the website so that folks can give it to their IRA custodian if that's helpful, but not able to do a fair market valuation.
How many, approximately, investors are there? How many claimants? Sorry, what was the number again?
So on the investor side, I know that we sent out 373 notices. Some of those folks it might be the same folks, but they have got multiple accounts. I don't know the actual number of people, but there's 373 notices.
Thank you.
And then there's unfiled tax returns for 7 years. We have Weaver and Tidwell that's preparing those. We've been in contact with the IRS, told them that that's going to be filed that those will be filed by May 15th, the delinquent returns, at which they've said is okay. We're also concerned that there's the possibility of penalties by the IRS, which could be significant. And so we're in communication with the tax advisors and legal advisors to try to figure out a way to eliminate that penalty or dramatically reduce it. And we also have preliminary discussions with the IRS on that. So that is that's where things stand on the tax issues. And that's the end of my presentation. If the court's got questions, I'm happy to.
So now you're going to have Mr. Milligan give a presentation too.
Mr. White. Yes.
Mr. White, sorry, Mr. White, yes. Are we going to do it question and answer, or he's just going to do it?
What we had said was he would just do it because that's the way it's prepared. He's got a PowerPoint.
That's great. Okay, that works with me. Okay, thanks. Go ahead, Mr. White.
Would it be okay if I stayed seated?
Yes.
Okay, thank you. Okay, so the main purpose of this report and the forensic analysis was to answer two main questions. When did this fund cross the line into a Ponzi scheme or fraud? And what happened to the members' invested capital? And as we've seen earlier this morning, it's a hot button issue. So I think hopefully we can provide some information here today that's will direct the course of the receivership from here and answer the investors' questions.
And you're a lawyer. Or you're not a lawyer.
I'm not a lawyer.
I'm thinking, even though I'm going to let you tell the story in the narrative, that probably I should swear you in. I think because lawyers always have to tell the truth and they have to have candor to the tribunal. And I think perhaps I'm going to let you still do everything you're doing, but I'm going to swear you in. Go ahead and raise your right hand. Stand up. Yep. In the testimony you're about to give, do you solemnly swear or affirm you'll tell the truth, the whole truth, and nothing but the truth?
I do.
Yes. Now sit back down. You can do this in the narrative format, but I think that's probably more formal and correct. Go ahead.
Okay. So it's based on the evidence we've received and reviewed, which is the fund's accounting records, bank records, some emails, as well as publicly available information that we've deemed relevant and accurate. And, our view is pretty stark that this was a Ponzi scheme from the very beginning. The very first distribution was paid prior to any loans being made. And we'll get into more detail later. But so the distributions were declared and paid of purported profits that either hadn't materialized at the time in terms of cash flow or never materialized. And then also in the investigation uncovered numerous badges of fraud. So what happened to the members' capital? I think a lot of it was paid back to investors. Profits were declared in excess of actual profits. And so money was paid to investors in the form of distributions and profits when it was really a return of either their own capital or the other investors' capital. Certainly money was misappropriated, and we'll get into that through self-dealing, internal conflicts of interest and internal transfers between the fund and affiliated private Austin or CCG entities.
For a minute, I want to know, is this the first time that this type of report has been given about kind of this investigation? Like, if investors are watching, you think this is the first time they're getting this kind of story? I'm getting some nods. So it's the first time I'm getting this full story. So I'm wondering if you've communicated to anybody. This is the day we're doing this.
This is the day. And
Got it. That's helpful. That's helpful. I mean, I think I understood that. I just want to make sure. So this is kind of your efforts to look into all of this. We are now telling the people who are interested, maybe watching on the video or sitting in the courtroom, this is kind of maybe the first they've heard about some of your digging into these various activities, correct?
That's correct. We did a report in April or early May last year that was a review of where the books and records were, what the assets were at the time. This is a much more comprehensive.
That's what it felt like to me.
investigation.
I was just making sure. I hear a lot of work. I hear a lot of cases. This was the first time I think I was seeing this in this case. So
Yep.
I wanted to make sure that it's probably the first time they were seeing it too. Okay, go ahead.
Okay, so just to level set a little bit in terms of how the cash flows are supposed to work in an investment fund. So from my perspective, there are two categories of cash flow. There's the principal and then there's the profits. So in the principal bucket, members invest capital into the fund. The fund then uses that money to make loans. The borrowers then at maturity repay the loan. And the fund at that point can either issue new loans or pay members back their capital. On the profit side of the equation, borrowers pay the fund fees and interest for the privilege of borrowing the principal from the fund. The fund has operating expenses, most of which are management fees. There are other expenses like tax preparation and when an asset or a loan is foreclosed upon in the property, or the fund then owns the property, there are property taxes and other expenses. Typically, a loan loss reserve is set up to help the fund manage through bad loans when they inevitably happen. And then the remaining money is distributed out to investors or members. I'll use those terms interchangeably, but the net profits are distributed out. And really the only time those buckets, those cash flows should interact is when members reinvest their distributions. So the goal of the fund is to maximize the time that its capital, the invested capital from the members is being put to work by being lent out to borrowers and earning interest and fees. It is a challenging endeavor. You're trying to maximize that time while also maintaining liquidity to meet the draw requests from the borrowers, meet redemption requests from the members, as well as making sure you have adequate funds to meet operating expenses. It is a challenging proposition, especially as the fund grows. So the fund is governed by the private placement memorandum and the LLC operating agreement. Both of these documents require the manager to distribute the net profits to members on a quarterly basis, and it defines net profits as the gross income less operating expenses and an allocation of income for loan loss reserve. The distributions are to be made on a quarterly basis, in arrears, and with the caveat that cash is available and making the distribution will not impact the continuing operations of the LLC or the fund. So that's an important caveat that we'll touch on again. Okay, here's a look at the span of the member investments from starting in June of 2010. The fund grew to over $30 million of invested capital, ignoring reinvestments at the moment, by over 30 million by 2014. Then you'll notice the blue bars represent net investments or redemptions for each month. So starting in about 2015, there were the first wave of net redemptions. I suspect that is due to the 2-year lockup period for the initial investment for investors. So investors who started in 2012 could get their money back in 2014.
I can't see this very well. Are you just the numbers, like the dates? I hear what you're saying, but like the bottom, the x-axis and the y-axis are not something that I can see very well. Can I get a copy of this? Is there any reason why I couldn't get a copy? If you send it to my email, that 201.solution.
Yeah.
Okay, that'd be great. I just would like to have it going forward. Thank you.
Do you want us to do that right now?
No, I don't have to. I mean, I'm picking up what you're saying, but I think it would be good for me to have this context because I think this is helpful context for me.
Okay.
Go ahead.
And then the fund peaked in 2020, and then there were consistently net outflows, net redemptions thereafter. Flipping to the asset side of things, the fund made its first loan in August of 2010 and peaked again in early 2020 with just under $50 million of loans. These are book balances, so they include things like accrued unpaid interest, accrued unpaid fees. To steal your phrase, this was not a good fund. Bad loans were made early. So the blue section at the bottom here are distressed loans that went into foreclosure or bankruptcy, or remained on the books when the receiver took over, and has had trouble recovering on them. So it's seeing this amount of distress in the portfolio, really cast doubt on the ability to pay out 10, 11% a quarter. Foreclosures foreclosures and bankruptcies by borrowers don't automatically equate to losses, but they certainly increase costs, delay the timing of recoveries, and most definitely reduce the performance of the fund. This is a look at the revenue of the fund each year, broken down by cash interest, PIK interest, which is payment in kind, where rather than the monthly interest being paid by cash to the fund, the loan balance is increased by that amount. And then prepaid interest is the concept where this happened at the closing of loans, where the fund would net fund the loan by the amount of prepaid interest. So if it was a $500,000 loan, they may hold back $50,000 for prepaid interest, in which case $450,000 would be issued, $50,000 would be reserved, and accounting entries would be made each month to recognize a portion of that interest until the prepaid interest reserve was depleted. It's not too dissimilar from PIK interest in that there was no cash coming in, and the recovery of that revenue occurred when the loan was paid off. And neither prepaid interest or PIK interest by itself is all that concerning. That's a pretty standard thing in lending, but it becomes a challenge when you're recognizing revenue on paper without collecting the associated cash from it, and then using cash to pay distributions to members. So on this page, we take a look at the net operating income or profits versus the amount distributed to members. You'll see the blue and the green lines here track each year up until about 2017 when they diverge materially. And so this is, the majority of the money went out here. The fund basically didn't make profits starting in about 2019, but paid out consistently 10, 11% in distributions. It's a little bit, this understates the over distributions, because the blue line is net operating income. And so this includes things like PIK interest, prepaid interest, and non-cash items that were flowed through to the profit line, but the cash may or may not have ever been received. But as a result of the distributions paying cash out, that's kind of where we run into trouble. So the PPM actually has some language around this exact situation. It says, to the extent cash distributions exceed the current and accumulated earnings and profits, they'll constitute a return of capital. So my contention is the profits were declared, even though associated cash was never generated from those profits. And so payments out to members was a return of their capital. Part of why this was able to continue on for so long was about 50% of the distributions were reinvested. So a 10 or 11% distribution was really only required 5 or 6% of cash. The rest of it went to increase investors' capital accounts. Okay, so talk a little bit about what a Ponzi scheme is, some red flags associated with it. According to the Securities and Exchange Commission, a Ponzi scheme is an investment fraud where purported profits are paid out of investors' capital. New investors are required to provide new money to the scheme in order to continue the distributions. The SEC lists eight red flags, and we'll walk through each one of those and how they relate to or apply to this situation. But ultimately, Ponzi schemes collapse when new investors are not able to be found. So the first red flag is high returns with little or no risk. Every investment has risk. That's just the nature of it. The risk reward, the higher the risk, the higher the required return. This fund was a hard money lender, which meant it lent money to borrowers at high interest rates and high fees. Those borrowers who utilize hard money lenders have exhausted their lower cost, more traditional options, been declined by the likes of banks and credit unions. And as a result, the borrowers are higher risk, meaning more defaults, foreclosures. And so, despite the claims that the fund made about its lending parameters and discipline around loan to value, the fund was not immune from the fact that it was lending to high risk borrowers. And experienced lots of foreclosures, Chapter 11 bankruptcies, pretty early on in the fund. Another red flag is overly consistent returns in investments, particularly over a 12-year period. There are cycles in the investment world, and yet the returns from this fund were remarkably consistent. Ponzi schemes typically are unregistered and unlicensed. The fund touted that it was a Regulation D security filed in all 50 states. And it did file a Form D pursuant to the Securities Act of 1933, which sounds more impressive than it actually is. Form D is a notice that you are claiming an exemption to that law, and what that does is it restricts your allowed marketing and advertising efforts, and it also limits the fund to less than 35 unaccredited investors. It provides a little bit of information to the SEC and to the public around the names, addresses of the principals, as well as some limited financial information. And while they touted this was a Regulation D security in the investor decks that I saw, it was detailed in the PPM that as a risk. So they didn't misrepresent that aspect of it in the document. In 2016, the fund received some legal advice that it had serious compliance deficiencies with multiple of the securities and investment laws, and was likely not exempt from the Securities Act of 1933, or the Investment Company Act of 1940, or the Investment Advisors Act. And so the recommendation was to wind down the funds, both the high yield fund and the opportunity fund. and to start over with a more rigorous compliance posture. The SEC says to avoid investments if you don't understand them or can't get complete information about them. This fund strategy wasn't overly complex. Everybody, or most everybody's familiar with mortgages. That's what they were doing. But the reporting and the financial disclosures were extremely limited. Many investors had trouble getting just basic balance sheet and income statements. A snapshot on the right is of what was actually provided to one investor, which is a balance sheet that just shows five line items. And then the income statement shows income, expense, and net ordinary income. It's not very helpful or insightful. At one point, there was a push by an investor to have the fund conduct a true third-party audit. After several months of emails and conversations with Mr. Buchanan about an audit, Mr. Buchanan committed to raising the issue at an investor luncheon. And there's actually a YouTube video still out there that shows this. And he did raise it at the luncheon and committed to putting it to a vote of the investors. It's our understanding that vote never occurred and no audit was ever conducted.
Just seeing if I can see it better with that. Not really. Sorry. Go ahead.
Along the lines,
Don't have very good. I have progressives, so it could be me. But it was a little even the numbers. But if you provide me with this copy, I'm going to be able to see some of it. I think. Thank you. Like I can't see that exhibit. The statement that was provided.
And so along the lines of the secretiveness of the fund. When pushed for financials and pushed for questions, even as early as 2013, the response was a threat that if you don't like this level of reporting, we've got plenty of folks who do. You can just have your money back and go on down the road. Issues with paperwork, we're all here because of that. At least 36 lawsuits were filed, most of which were requests for books and records. The difficulties receiving payments has been discussed earlier today.
When did the first lawsuit get filed? Do we know that? Does anybody in the room know that? I don't know.
I
Approximately
don't.
when?
My guess would be early 2023, but
Okay. Thanks. Ms. Anton Georgie, when did y'all file your lawsuits?
I don't have that. Off the top
That's
of my
fine.
head.
I was just curious for a timeline. Fine. Go ahead.
so difficulty receiving payments, particularly late in 2022, 2023, when the money was running out. It was these are kind of typical responses or lack of response that investors would get, often delaying, committing to the redemption, saying we need to wait till a loan pays off in a couple of weeks, just seemingly buying more time to figure out where to uncover the money to meet the redemptions. And then the last red flag is if there's a significant emphasis on attracting new investors and incentives for doing so. This fund early on ran investor or bonuses for investors who introduced new investors, whether it was 1 or 2%, was added to their balances. They ran a contest here and to try to get new introductions, new investors. And then it seemed like at the end of investor letters was the ubiquitous statement: if you know anybody, we're doing great. If you know anybody who's would be a good fit for an investor, let us know. We'd love to meet them. So I think each of the red flags fits in this circumstances in one way or another. So then we'll talk about what actually happened here. So Ponzi schemes rarely are a master plan from the beginning to defraud investors. Small unethical decisions or errors, and then decisions to cover up those errors snowball into massive unsustainable frauds. So this is kind of the slippery slope we were on, or the fund was on, and we'll step through each of these items. So accelerating profits, there was an aggressive accounting scheme here with a bias towards showing a good, strong return, paying interest out. So this slide shows the first 4 transactions of the fund. In June, there were two investments, $50,000 by the first investor, $25,000 by the second. On August 20, I believe it's 25th, the fund declared and paid its first distribution of profits, which is problematic because it hadn't made any investments, any loans yet.
I'm sorry, could you repeat those dates?
So the first investment was June, I think it's 9th. June 25th was the second investment, and August 25th was the first distribution. Now, I mean, it's a small amount. Admittedly, less than $1,000 was paid, but it was there was no other place for that cash to come from other than to come from the investor's own capital. Okay, so I wanted to just talk through 2 hypothetical loans to give you a simplified hypothetical here of what was happening and show the difference between paper profits and realized cash returns. So each of these is a $100,000 loan at 12% interest. The top one pays $1,000 of interest each month. The fund receives $1,000 each month, and at the end of each quarter pays its members $3,000 of that profit. So by the end of the year, it had a net cash flow of $12,000. It had a net revenue of $12,000, and it paid out $12,000. We're ignoring management fees and expenses for these. In contrast, when it's payment in kind or PIK interest, the cash flows are limited to the initial outlay, the initial funding of the loan, $100,000, and at maturity, the loan is paid off with the accrued PIK interest. So here, each month, $1,000 is recognized in revenue, $3,000 is paid out as distributions to members. But unlike the top example where the borrower paid cash interest, there's no money coming into the fund in order to fund the distribution to members. And so that money has to come from somewhere. And it's my contention it came from investors, new investor money or prior investors being capital. Okay, so to further dive in, this is an actual loan made by the fund. It was funded in 2012 and it was repaid in March of 2013, netting a profit for the fund of just under $7,500. Excuse me. And so what happened here was PIK interest. The loan was funded in February and March in two advances. And a year later, the principal was repaid with the interest. Each month, while the loan was outstanding, the fund recognized revenue associated with the PIK interest, and the loan balance increased. So that revenue flowed into the calculation of the net profits and what was paid out to investors. So the amounts of net profits distributed was paid from cash from somewhere else. Now, ultimately, the cash flow caught up with the paper profits in this example, but that didn't always happen. And so in Fulshire, this was an early loan in 2011, but the name may be familiar because this is still an REO property that the fund owns. It was funded in 2011. It was foreclosed. The collateral was foreclosed upon in 2014. And here in this example, there was almost $800,000 over the 4 years that the loan was outstanding. That almost $800,000 in revenue that flowed down to the the calculation of distributions and ultimately paid out to investors. But the cash inflows from this borrower were only approximately $450,000. And since this loan was never repaid, the actual cash returns have never caught up with the paper profits. Self-dealing in this fund started almost immediately. There were a couple of the initial loans were made to benefit David Owen and Robert Buchanan, as well as their home builder entity, Pride of Austin Homes. Mr. Owen was facing financial ruin and contemplating bankruptcy when he asked that the fund provide 2 loans. 611 Bissonnette is the house his residence. The fund paid $14,000 to a bankruptcy attorney, and that loan remained on the books for an extended period of time. 525 Live Oak was a ongoing project of Pride of Austin Homes. The fund lent $15,000 in October 2010 and $17,000 in February 2011, and then ultimately, bought the existing mortgage from the incumbent lender in 2012. And we'll get into this next in a subsequent slide. But when 525 Live Oak was a loss for the fund, the property was sold for an amount less than the loan balance. For Mr. Buchanan, the fund helped with the acquisition of 105 Pine Barrens, which he built as his personal residence. He had a $400,000 construction loan from Independent Bank and borrowed over $380,000 from the fund to supplement the construction loan. In 2014, the construction loan was converted to a permanent mortgage or 30-year mortgage with a deed of trust filed with the county clerk in favor of Independent Bank, and no repayments were ever made to the fund. And like Live Oak, we'll talk about what happened to the balance of the fund or the loan. So no loan loss reserve was ever set up. And I think this was a bad decision when dealing with high risk borrowers, and there was no mechanism to absorb some losses. You're kind of borrowing from profits to absorb losses and help to smooth out the earnings overall of the fund that are natural from dealing with these high risk borrowers. And loan loss reserves are pretty basic element of lending, and is a big focus of regulators throughout the banking industry. And so, like we talked about earlier, the loan portfolio underperformed from the get-go. This is the loan schedule from the end of 2012. There are 9 loans totaling just under $9.4 million of total committed loans. Not all of this was funded at this time, but the 4 that are highlighted here in pinkish color represent about 77% of the loan amounts. And we talked about full share. That's the FP1 and FP2 right in the middle. Those were foreclosed upon in 2014 and remained an asset of the receivership. South Austin White House in Midtown were and similarly, I can't recall if they were foreclosed upon or filed for bankruptcy, but similarly faced distress. I would also note that of the 5 loans that are not highlighted, 2 of them are to Pride of Austin Homes, which is the Owen and Buchanan home builder at the time. Bruner is his mom. and MDG was his wife. So then we've got aggressive accounting by accelerating profits and paying distributions out from it. We have some self-dealing, utilizing the assets of the fund for personal benefit. We didn't set up a loan loss reserve, and then we run into trouble in the portfolio. And this is where bad decisions happen. What he did was, rather than recognize the losses at the time and impact the performance of the fund, balances for these loans were transferred. So 525 Live Oak was the loan we talked about earlier. That had a $94,000 shortfall when the property was sold. $60,000 was transferred to 611 Bissonnette, which was the loan to Mr. Owen. Not quite $35,000 was transferred to the 105 Pine Barrens, which was the loan we talked about to Mr. Buchanan. And then 105 Pine Barrens was the one where there was a construction converted to mortgage loan from Independent Bank. And so the loan back to the fund was never repaid. Instead, the over $416,000 of the loan balance was transferred to these two loans, West Park and 12th and Hargrave. What's significant about those loans is they were both at or in or near foreclosure. And so, it seems to me that the purpose of doing that would be, you could pad the balance of a foreclosure if there is a loss. Yeah, you may be able to recover the amounts from through the foreclosure process, and if not, then at least you can blame the loss on the bad borrower.
How much longer do you think you have? I need to give my court reporter a break. I mean, I was thinking we would finish at 11, but we might be going longer than that. So
probably about 30 minutes.
Okay, then we need to take a break. Let's take a 15-minute break, and I'll come back at 11:15. Thanks.
All right.
Thank you. You may all have a seat. Thank you. We are more comfortable now. All right, are you back? Ready? Then we'll go back on the record and we'll pick back up where you left off. Thank you.
Okay. So we talked about accelerating the profits, the aggressive accounting, self-dealing, the lack of a loan loss reserve, some troubles in the loan portfolio. And so then we got into the hiding of losses and the transfers of those loan balances. There were others through 2013 up to 2018 where loan balances from loans to CCG or related parties were transferred either to other foreclosed loans or just kicking the can down the road and transferring them to other CCG development loans. And then we come to what I can only characterize as fraudulent entries. There were two loans to the Falls, which was an event center developer for the development of properties in Roseville and Cedar Park. And there was over $6 million of revenue booked at the end of 2015, at the end of 2016, and at the end of 2017 associated with these loans. The first entry of a little over 500,000 was at the end of 2015. This was before the loans even funded. And then one of the Cedar Park loan funded in March of 2016 and was repaid in July of 2016. The other one was already in default by July of 2016, ultimately filed for Chapter 11 in 2018. And the loan was sold by the fund for $3.7 million, which was about $1 million under the principal balance and accrued unpaid interest. In scrutinizing these entries, it's typically the offset you look at where the entry was made, and then what the offset was. So this $6 million was one half of the entry went to increase the revenue of the fund. Typically, if it's interest, and is paid in cash, the other side of the entry would be an increase in cash. For these, it went to an account called accrued income, and then it just sat there and nothing ever happened. So when we got involved in the spring, there was an asset account for $6 million called accrued income. And so there's no evidence to support this revenue being recognized. There's no evidence, no documents to support that there should be a $6 million worth of assets on the books. So this, to me, looks like just an effort to increase the revenue, the net profits in those years in order to declare distributions consistent with what the history was. You can see this is a view of the interest recognized in each of those years. The red box here highlights the PIK interest, which is predominantly the falls, the three falls entries that we just looked at. And then we transition into misappropriation of funds. We've already talked about one of 5 Pine Barrens. He borrowed used funds from the fund to build his own house and never repaid the fund. He did it again in 2018. He borrowed $1.2 million to construct 1610 Heather. It's our understanding that he lived at that house until he was evicted by the receiver in the fall of 2024. There was also issues of paying off junior liens ahead of the fund's liens at closing. So 1307 Justin was a loan to CCG Development. It was an A and a B unit development. So can't remember if this is A or B, but at the closing, because Mr. Buchanan was both the borrower and the lender, in his role as the lender, he could state what the payoff amount was. And so in this instance, he paid almost $128,000 to the Pride of Austin Fund, the high yield fund, and over $600,000 to the U.S. Treasury for tax liens on CCG Development. Those liens were junior to the fund's first lien mortgage and should not have been paid until the fund was paid in full. Similar issue at 525 Live Oak and also at 1610 Heather, but because the receiver was determining the process to pay off for Heather, we were able to get paid at closing ahead of those tax liens. There were, when we first looked at the books, there was, it showed about $2.7 million of cash on the balance sheet, but there was only about $22,000 or $24,000 in the bank account. So a deeper dive into the cash transactions in both the accounting system and the bank account uncovered about $3 million of transfers to CCG Development that were never booked in the accounting system. And that's where the first one was in late 2018. And on this graph, you can see the yellow and blue lines track in the beginning part of it and then diverge. And the primary driver of that diversion are these unbooked transfers. At 2209 Iva Lane, this is an example where the fund lent money to CCG Development to redevelop this property, and no funds were paid at closing back to the fund. This is a snapshot of part of the closing statement where the loans and liens are listed, and it says none. And so as a result, the title company sent the money due to the seller and not to repay the mortgage first. Part of how this came about was the money that went to buy the lot at 2209 Iva was on the closing statement of the purchase. It wasn't shown as a loan as you would normally see on the closing statement. It was just effectively a cash purchase, which was not the case. Moving on to other badges of fraud that we identified. The first was just misleading information. This pie chart was one of the limited items or bits of information that was provided to both current and prospective investors. And it purports to show assets under management, which is a common industry term that is meant to reflect the market value of the assets that the investment fund is managing on behalf of investors. It's a widely used metric. It broadcasts to the market, to investors, a track record of success, a scale of operations, and it provides the higher the number, it conveys credibility to the fund. What was included in these pie charts was a number that was almost 2 times reality. Mr. Cannon at Investor Luncheon described the number that went into there as the collateral, the value of the collateral that is pledged against the loans, which is just it's a distortion of the metric. Also on this chart, there's a note saying $7.4 million was in escrow for unfunded construction loan draws. I didn't see any evidence that any money was ever escrowed for that purposes. And then there's a reserve account of almost $3 million. And at one point there was a reserve account, but I think it was fairly nominal amount. There were 2 sets of books, which is a major red flag. The first one on the left was the loan schedule that they passed amongst themselves internally. The one on the right is what was circulated to investors. And the biggest difference between the two is the loans that we've just talked about to themselves were omitted from what was circulated externally. Mr. Nix has discussed at the status hearing, the fund didn't file a tax return from 2016 onwards. Despite that, K-1s were still issued to investors, showing their grossly overstated income. I looked at just the magnitude of transactions and going into the accounting system, just to understand what the actual activity was of the fund. And as you can see here, so this line shows the average number of transactions per month. It's a 6-month moving average. Try to smooth it a little bit, but basically as the fund's growing up until 2015, there's the increase in activity, or more borrowers, more draws, more expenses, more investors. So that makes sense. In 2015, the activity dramatically decreases. And by about 2021 or so, we're back to a level of activity that was from when the funds just got going. We've talked a lot about self-dealing, a few other things to note in terms of badges of fraud. The loans to CCG development and to family members and affiliates, they were allowed to do PIK interest. So they were given the benefit of not paying the interest in cash, whereas third parties were not and were required to pay the contractual interest in cash each month. These loans typically had lower interest rates and fees. There was almost no documentation of the loans, or extremely limited. Third-party loans would have inspections and the draw requests would include detailed scrutiny to validate that the work had been done. No such documentation exists for CCG development loans. And then we've talked about diverting of funds to affiliates or itself. This includes investing Pride of Austin High Yield Fund capital in the opportunity in related funds. The Opportunity Fund, is it CCD Equity Fund 1 and Equity Fund 2, which I don't have the books and records of those funds, but the potential for double dipping on management fees exists as a result of funneling investor money into that secondary fund, or those secondary funds. In addition to, we talked about earlier, the paying of junior liens, and because he was both the lender and the borrower, he could determine the payoff amount. This included what interest was due at closing, and oftentimes CCG development loans, when they were repaid, were not repaid with the full contractual interest. So this is an example from 1207 Cullen Avenue. The $1.44 million loan was outstanding for 2 years. But there were 22 draws, 23 advances, and by my calculation, almost $250,000 of interest had accrued while the loan was outstanding, and yet $9,000 was collected at payoff. The high yield fund invested in the Opportunity Fund, and part of the Opportunity Fund's pitch was it was allowed to do a little bit more flexible lending, could do 5-year loans, could do second liens when the high yield fund held the first lien. Well, that introduces the potential for a conflict of interest, because the interests of a first lien lender and second lien lender may diverge depending on the circumstances. And then, look in the last slide here, it's back to the self-dealing and being on all sides of the transaction. For 509, or sorry, this on the left is a snapshot of an investor deck that Robert was just beginning to present at these investor luncheons, and he often touted that being the bank, those who know interest earn it; those who don't pay it. He was being both the bank, but he was being the bank for himself. And the email exchange on the right was a scenario where they brought to an acquisition of a lot. They brought the builder, the borrower, and the lender all together, and so it makes it virtually impossible to serve the best interests of the fund when you're in all sides of the transaction. So that concludes the presentation. To the extent that folks are watching on YouTube on the broadcast and have questions, we're happy to review them and respond. I'm sure there are questions. We'll aggregate the same or similar questions and provide responses.
Thank you. I'm trying to figure out how to stop share. There we go. Now we're back to the camera feed in the courtroom. That was very thorough. I mean, I'm sure I could ask you questions, but appreciate the thoroughness to that. I know there are some other parties represented in the courtroom, and then here per se. That was a lot to take in. Does anybody have any questions or that you'd want to ask?
No questions, just appreciate the report.
Thanks.
I actually do have a couple questions.
Okay.
I
think we'll stay there, but just be aware of the microphones. Mr. Akinelli's taking a record, so rather than make him come up here, we'll do it this way, but just talking to the microphones.
May I sit?
You may, yes.
Thank you. I want to join the court in thanking Mr. White for this effort. It seems like you've been very diligent and spent a long time looking at a lot of information. I just had a couple of questions, and I'm sure they won't be the last, but I was trying to figure out the distribution versus profit spreadsheet that you have there. And I don't know if you could pull that back up.
Well, we can't because I just,
Sure.
it's too many steps.
No problem. Okay, so what I was trying to figure out there is the lines that you had there, one of them was for the revenue, correct?
He can look at it, but I don't think we can pull it up for me to see it. I'd rather keep this feed live.
Is there any way that the two lines that you had on that chart, the distribution versus profits chart?
Yep.
One of the lines is for revenue, correct?
One of them is net operating income, which is
Okay.
profits. The other is the declared distributions.
Okay, and I noted, or what I can recall is that in about 2015 or 2016 is when you start to see a divergence.
Correct.
Okay, so prior to that time in 2015, 2016, the distributions did not exceed the profits.
So the distributions were in line with the profits as they are entered into the accounting system.
Did the net profits exceed the distributions prior to 2016?
The net profits, no. And so one of the things I'll point to here is maybe helpful. The full share loan that we went through, where there was $800,000 of revenue associated with that loan, but only $450,000 of cash flow into the fund. That would the lines on this chart include $800,000 of revenue from that loan. And so there's there's paper, there are accounting entries and paper profits associated with that loan embedded in 2012, 2013, 2014, where there was no cash flow or commiserate cash flow.
I see. So the distribution versus net profits that you had on that spreadsheet, the income that you have is not what you would say is necessarily the true income.
Correct.
The true net income. So, and we don't have that analysis where we do have a comparison of the net true income.
There wasn't one in this report, no.
Have you conducted that analysis?
I think I have the majority of it, but
Are we going to expect a supplement with that? So we know what the real deal is?
but yeah.
I have a couple more questions. So I understood you to be saying that there were a couple things that were inflating the profits, right? And that's, I guess, in relation to that net income that you have there, correct? Okay, and one of them you mentioned was the payment in kind interest. And you said that this is legitimately utilized by businesses sometimes.
Mm-hmm.
When is it legitimate to use it and when is it nefarious?
So the issue I was trying to point out is to recognize revenue from PIK interest and then pay out a dividend in cash before you receive the cash from that loan becomes problematic from a fund management cash flow perspective. Because you'll remember the definition and the language in the PPM and the operating agreement around when distributions are supposed to be made is when there's cash available and when it will not impact the future operations of the fund. So recognizing revenue from a non-cash item, PIK interest, paying out cash, there's no cash available to make that distribution because you never got the cash. The cash came from somewhere, other investors' money, capital. And it would impact the future operations of the fund because now you have less money to invest and lend out to borrowers.
So if I'm understanding you correctly, what you're saying is that it's not necessarily that there's something wrong with using the PIK interest. The problem here was that distributions were being paid based on that, and it should not have been included when calculating what distribution should have been paid.
Yeah, I think that's an accurate way to.
Am I understanding?
Mm-hmm.
Okay. And then I also noticed that you mentioned prepaid interest recognition is also inflating the profits, maybe?
I'm sorry, I couldn't hear. Recognition.
Yes, excuse me. So the other item that I thought that I heard you talk about in terms of when profits might have been inflated was prepaid interest. Could you just explain?
Yeah, so the issue there, it's similar to PIK interest in that if you have a loan that was, call it $500,000, and you reserve $100,000 for prepaid interest, right? So what the fund did was it would send $400,000 to the borrower. It would, in the accounting record, show a loan of $500,000, and then it would recognize revenue each month. It would not actually realize that revenue from the prepaid interest until the loan was repaid. And so it's a similar concept to PIK interest in that there are paper entries and paper profits, but no cash flow associated with it at the time that the distributions are made.
Okay, and then there was something in terms of also hiding losses through the balance transfers. When did that start happening?
The first instance was in August of 2013.
And with respect to the distributions made on, I guess, not phantom revenue, but these payment in kind interest and these prepaid interests, when do you first start seeing distributions paid based on those additional inputs?
There was PIK interest in 2010.
And your position, not your position, excuse me, but what you've found was that was being used to fund distributions. I mean, or to justify the funding of distributions?
It was used to determine the amount of distributions to make, regardless of whether or not the cash was available.
Okay. I noticed in a lot of your charts around 2015, or in your presentation around 2015 and 2016, is when you start to note some curious things, right? The legal advice in 2016, the decline in accounting activity starting in 2015. Do you have any conclusions about what was happening around that time?
I suspect it was a snowballing effect of prior bad decisions covering issues up, snowballed into bigger and bigger problems.
But around that particular time period, was there, did something significant happen there? Was there a significant change there?
Not one that I can point to.
Okay. All right. I again want to thank you, and I want to thank you for your patience with explaining some of this stuff to me. And I guess the only thing I would ask is to just confirm from what you've reported here, we see reasons to be suspicious about what was happening from the very beginning. But in terms of actually seeing and being able to definitively say that distributions exceeded net profits, we don't actually have that calculation in what you've presented, correct?
So the very first distribution was made prior to any revenue, let alone profits being generated. And nothing was in the report to detail exactly what you asked for before, and we can do a supplement to that. But because of the PIK interest and the cash flow associated with that, distributions were made in excess of what cash was available from the operations and profits of the business.
And other than that first 8% distribution, when does that first start happening?
It's the whole time.
I'm sorry, I understood that what you had presented in the report in terms of the net profit analysis included these items that you didn't think should be included in there. So how do we know that it was happening the whole time?
So there was a chart that showed the PIK interest in the revenue breakdown between prepaid interest and PIK interest and cash interest.
Mm-hmm.
The PIK interest and prepaid interest was happening the whole time. And as a result, just profits were being declared that there was at the time of for that quarter, there wasn't the associated cash flow.
Okay, and just so I understand, are you going to supplement with a report that shows, a comparison of actual net profits that you think are legitimate versus distributions?
Yeah.
Okay, great. Thank you. I don't have any further questions for now.
Thank you. Mr. Nix, back to you. Is there anything else that you want to report out to the court? That was very helpful. I think perhaps maybe it addressed some of the issues where we started today. And what's next?
Nothing further today. I suppose we could talk about, like I said, we're going to file the distribution plan within the next 30 days. If the court wants to talk about scheduling now, we can do that.
We might do it off the record. We can leave up you two, but we might do it off the record. Just 'cause it's easier to talk dates off the record. Ms. Racanelli tends to get upset because I make it very conversational, and it's difficult to have a record conversation that's conversational. So, within the next 30 days.
Within the next 30 days, we're going to file the distribution plan. Based on the Rule 11 agreement that we have with Ms. Anton-Georgi's clients and Mr. Mercer's clients, they have 21 days at that point to object to the other claims report and the distribution. I think it includes the distribution plan in the Rule 11. I can't recall, but that's at least the way that I was thinking of it. So what I was thinking is we'll file the distribution plan. Anybody that has an objection to it should make an objection within 21 days.
And then we'd have a hearing after that.
Have a hearing.
That sounds right to me. Let's go off the record. Thank you for everything today. We appreciate that. You're going to email me to my submission email, that PowerPoint. And then we'll go off the record to discuss when our next setting is.
Before we go off on the record, Your Honor,
sorry, let's go back on the record. Yes, Ms. Anton-Georgi.
I'm sorry to interrupt. There's just one thing I wanted to clarify. In the receiver's report, he suggested that they will be filing lawsuits against what they call net winners. And to the extent that these are judgment holders, and this is a conversation I had with the receiver's attorney, that to the extent that they are purporting to file lawsuits against judgment holders, we would ask that a motion for leave before filing that lawsuit be instituted.
I think it's already in the, what does it say in the receivership order? Do you already have to get permission from me, or do you not?
There's a provision in the receivership order that says that if there's going to be a collateral attack on any existing judgments, then we have to come to the court to get leave.
That was a very lawyerly answer. So,
I didn't write it.
I know. I'm just trying to understand. Do you believe to file any lawsuits on behalf of the receiver, do you have to ask for court?
No, not under the order, other than the collateral attacks.
Other than the collateral attacks, okay.
And so
then I think you need to file a motion if that's what you want. If you're wanting to restrict something more than what is in the current order, you need to ask for it in a more, if it's just interpretation of the current order, which I think might accomplish what you're asking for, I don't know, but I have an order in place and I think you're asking to change the terms of it.
And what I can also say is before any lawsuits are filed against Ms. Anton-Georgi's clients, I'll visit with her.
Okay. Well, there you go.
We can confer, and if she disagrees.
Well, that's on the record. You got that on the record.
Right. And I would just posit that, any motion, any lawsuit that seeks to recover fees awarded in a judgment is a collateral attack and would require a motion for leave.
Without looking at it more carefully, I'm not prepared to give you a ruling on that. You're asking me to box myself in on a particular posit in the law, and I just am not there yet. I haven't had a chance to think about it as much as you have. You may be right. That may be where I land, but I haven't landed there yet. Okay, thank you. We can go off the record. All right, so 30 days from today. 15th. Well, that'd be as the earliest.
Say that again. Yeah, I would say 21.
What is, I'm not looking at it. Jury. I'm still not on the family docket. I voted the family docket in July. So if we could get this done at end of June, that would be better for me.
That's what I was thinking.
Not to say I would give you time when I go on the family docket, but it's just easier when I'm not on it.
Sure.
So, we could,
This week? Yeah, this week.
okay, now we will roll into, I think, the assigned docket to me for the afternoon. Hold on one second. Let me just finish signing the order. that I was just referring to. There we go. To file. Okay, so I think I have 3 cases as set. We had more than that, but some cases have passed, so maybe just 2 cases. We'll see. I have so let me know if you're here and how long of a hearing you need and if you need a record. I have Tara Roma versus NSSW Development, LLC.
It's Benjamin Hunt here for Ragland and NSSW.
Anybody else here on that case?
Yes, Kaylee Smith here on behalf of the plaintiff.
And back to you, Mr. Hunt. How long of a hearing is this?
It shouldn't take much time at all. Maybe 5-10 minutes.
5-10 minutes. And do you need a record?
No, Your Honor.
And Ms. Smith, do you agree with that time announcement?
Yes, Your Honor, I do.
Thank you. And then I think we have 2 cases that we were told passed their hearings, Baldonado versus Howington. Good, they're not here. That's consistent with my understanding. And Nadam versus DR Trucking. Also consistent with my understanding that they have passed. Okay, good. And then lastly, we have a motion to approve settlement. I think I see them here. This is on the Benjamin Lloyd et al. Versus East Tech Electronics et al. And are y'all all here?
Yes, Your Honor.
Sorry, this is Patrick Weigel for the plaintiffs. It looks like my client may have just dropped off the Zoom. She may have a connection issue, but
Right. Well, we're going to start with the other case, so she'll have a few minutes to get back on. Oh, there she is. I see her coming back. And then we lost Mr. Dow just now. Interesting.
Oh no, I'm here.
Oh, there you are. Okay, it blanked off on my screen. Okay, I got it. I think everybody is now around, though. Hold on one second. What I'm seeing is I don't see Tanika. That's weird, right? We don't see, I think your client came back in because I can see her on the listed participants, but then I don't see her face on the screen. Are you having that same issue?
yeah, Tamika, are you able to turn your camera on?
Okay, something's happening. There, okay, it'll be a minute, but it's very dark camera, but we will see in a minute if we can make that work. But I'm going to start with the other hearing first anyway, gentlemen. So maybe while we're doing that, she can mess with her screen some and see if we can see her. Okay, let me do just the Romo versus NSSW Development and Ragland case. It seems like it's a pretty simple case, and so, or a simple hearing. So tell me what you're here on.
Yes, Your Honor. We're here on a motion for leave to file a third-party petition. This case is about alleged mold exposure to plaintiff Tara Romo and her daughter, who is renting and living in an apartment owned by NSW and managed by Ragland Realty. Ms. Romo moved into Unit 106 at around June 10th, 2023. On July 1st, 2023, proposed third-party defendant Alexis Flores Ramos moved into the unit right above hers, Unit 206. On that very same day, there was a water leak in Mr. Flores Ramos's unit that we are alleging was intentionally caused to break his lease. We are alleging that the water leak caused water damage to Ms. Romo's unit, which then facilitated the growth of mold in her unit. So we are moving to bring him into the case as a third-party defendant.
At this point in the case, Ms. Smith, this is pretty perfunctory, I think. It's a pretty pro forma motion. So The time to object is later, I guess, pursuant to CPRC 33. But what is your response?
Yeah, we're not objecting to him bringing in the responsible third party at this time.
Okay, so I'm going to grant this, Mr. Hunt. Did you provide a proposed order?
There should be a proposed order, yes, Your Honor.
But where?
I believe we emailed it to the filing website or email address. We're
gonna double check. We're gonna double check. Let me see from staff if they have an email to the 201 submission email address.
I will say we filed it, we emailed it, we were getting kickbacks. We sent it every which way we could.
Well, in Travis County, our district clerk doesn't like you to file a proposed order. She doesn't mind if you file it as an exhibit to your motion, but see, it's very different, I think, that in like federal court or possibly other counties around the state where you actually file a separate document that is a proposed order. She doesn't like that. The clerk's office doesn't like that in Travis County. So for anybody watching, anybody here, just a little pro tip, if you have a proposed order in Travis County, you can make it Exhibit A, Exhibit 1, but it actually just clutters the file and also is kind of difficult for us to utilize for a lot of different reasons. It's in PDF form and sometimes it's a JPEG of a PDF. And so it's just not the best way to do it. The best way is submission email. And we don't have yours by submission. The way a lot of people do, and it doesn't cause me concern, is they will do it and they will send it, they will put it in their box link. It's fine. I can usually find it there. Let me see if I can find it. No, I don't have it there either. So what I'm going to ask you to do is your homework now is to send it to me directly to my submission email. And that is 201.submission@traviscountytx.gov. Send me your proposed order. Don't make it ex parte, so copy everybody else on it. That goes to my submission email, and I will sign your order and file it with the clerk's office. And usually you get copies of that within 1 business day.
Perfect. Yes, we will go ahead and do that, Your Honor.
All right. Thank you. Good luck. You're excused. Man, I keep losing people. This is the wildest thing. I keep losing you. Maybe some of you were off camera and now you're on camera, but I cannot keep a screen. This is wild. Whatever Zoom is doing right now is like, every time I look up, it's like is a genuine Brady Bunch and like everybody has moved and you've changed spaces. Something is going on with my account. You may just have to ask them. Now I'm missing Mr. on my screen. I'm now Mr. Mike Weigel. There he is. Okay. Okay. All right. I think I'm going to have the correct parties. I'm missing Miss Roccanelli, but maybe she got off because you said you didn't need a record. Maybe she just went ahead and disconnected. I don't think they are saying they don't need a record, Alicia. So you are free to go.
Your Honor.
Oh, no, sorry, Mr. Ferguson, hold on.
Okay, I apologize for interrupting, Your Honor. But I would like to have a record.
Okay, that's fine. Let her set it up. She's going to ask you some questions to get it set up. And I'm going to make notes from the last case while she's doing that. That's fine. Totally fine.
Great, thank you.
Can I just get the witness's last name?
Thompson - Lloyd hyphenated THOMPSONLLOYD.
Tamika Thompson Lloyd, individually and as guardian ad litem for ML, a minor, and Benjamin Lloyd, versus Easy Corp, Funai Corporation, and East Tex East Tech Electronics. Let me at this time take the attorney announcements for the record.
Thanks, Your Honor. This is Patrick Weigel with Waters, Kraus, Paul, and Siegel on behalf of the plaintiffs.
Your Honor, Ken Ferguson with Gordon Reese Scully, Matsukani, with for the defendants in this case, Funai and East Tech.
Your Honor, Miguel Bustillos with the Fletcher Farley firm in Austin for defendant Texas Easy Pawn LP, which was, with respect to the style of the case, is incorrectly identified as Easy Corp Inc.
Thank you. Can you state what firm you were? It was a little garbled, your first line. What was that?
Sure. Fletcher Farley Shipping and Salinas here in Austin.
Thank you. And then I know we have the appointed guardian ad litem in this case. Can you state your name as well?
Of course, Luke Dow, guardian ad litem for the minor.
And have we reached a final settlement in this case as to all claims and all parties?
Yes, Your Honor.
Thank you. So at this time, we're going to hear testimony from Ms. Thompson-Lloyd with regard to the settlement with regard to the minor. Is that correct?
That's correct.
And who's going to take the testimony of the witness?
I'm happy to start off and they can all back clean up.
Okay, Ms. Thompson-Lloyd, yes, if you could unmute yourself. We have some questions to ask you, and you can lower your hand. And Mr. Dow, you can start first.
Thank you, Your Honor. Ma'am, will you please state your name for the record?
Tamika Thompson-Lloyd.
Ms. Thompson-Lloyd, good afternoon. You are the mother of Jamirical. Okay. You're her mother?
Yes.
And she is 8 years old?
Yes.
We're here about an incident that occurred on, I believe it was November the 21st of 23. Is that correct?
No.
It was March 8th.
Okay, sorry. I think I just put that down wrong in my summary. In any event, we're here about an incident involving your daughter, correct?
Yes.
All right. Now, she got a hold of a remote control and the small battery inside of that came out of it and she swallowed it. Is that correct?
That's correct.
All right. It lodged in her esophagus and basically burned a hole in her esophagus. Is that correct?
Yes, her esophagus and her right lung.
Okay. Obviously, she spent time in the hospital where she underwent surgery and was on a ventilator, correct?
That's correct.
She spent about 3 weeks in the pediatric intensive care unit. Is that correct?
That's correct.
Okay. Now, my understanding from the medical records and then talking to you probably about a month ago is that she's doing fine now. She's not having any continuing problems.
She's okay.
That's good news. All right. You engaged your lawyer, made a claim and ultimately filed a lawsuit against the named defendants. You've reached a settlement of your daughter's case pending this court's approval. Do you understand that?
Yes.
And we're here to seek court approval of that settlement.
Yes.
You understand that the total gross settlement is $1,100,000?
Yes.
You understand that there were case expenses in the amount of $117,306.16.
Yes.
And the attorney's fees total $393,077.54.
Yes.
And then Medicaid paid a bunch of your daughter's medicals totaling just over $170,000. Is that correct?
Yes.
All right. Now, I know Mr. Weigel is continuing to negotiate with Medicaid, but for now, we're going to keep that entire amount aside, and then any reduction he gets will be added. Any reduction he gets, that same dollar for dollar, will be added to your daughter's settlement. Is that your understanding?
Okay.
Okay. After those deductions are made, the net recovery is $419,547.38. Is that your understanding?
Yes.
Okay. Of that, we are asking that $370,000 be put into a structured settlement for your daughter.
Okay.
And that will pay out from age 18 to age 30, $5,664 per month. You understand that?
Yes.
So that guaranteed benefit is almost $813,000 from that structure.
Yes.
Okay. Now that leaves $49,547.38, of which you're asking that $14,547.38 be put into a custodial bank account for your daughter if there are any future medical issues, correct?
Yes.
And that the remaining $35,000 be awarded to you because you had what we call a bystander claim, watching all of this happen to your daughter, getting her to the hospital, things of that nature, correct?
Correct.
Okay. You understand that you don't have to settle your daughter's case. Instead, you could try the case to a jury. It's possible a jury could award her more than this. It's possible a jury could award her less than this. It's even possible that a jury could award her no money at all. You understand that? Ma'am, did you hear me?
No, you cut out. You cut in and out. I couldn't understand what you said.
Okay. What I said was, do you understand that you could have gone to a jury and tried this case rather than settle?
Yes, I understand that.
Okay. And a jury might have given her more money, less money, or no money.
Yes, I want to settle.
Okay. You want to settle as per these terms because you believe that that's in your daughter's best interest. Did you hear me, ma'am?
Yes, I want to settle.
Okay.
I want to settle.
And you believe it's in her best interest to settle.
Yes.
And you understand that if Judge Meacham approves this, that neither you nor your daughter can come back against these folks or their insurance companies to ask for any additional money.
Yes, I understand.
Okay. And you're asking the court to approve all of this?
Yes.
Okay, ma'am. Thank you very much. I'll pass witness, Your Honor.
Do any of the other lawyers wish to ask any questions? I'll go to you first, Mr. Weigel. I think you are muted. Sorry.
Thanks, Your Honor. I think that Mr. Dow covered it quite expertly. I don't think there's anything additional I need to ask.
Thank you. And now, Mr. Bustillos, do you have anything?
No questions, Your Honor.
And finally, Mr. Ferguson.
No, Your Honor, no questions. Thank you.
Thank you. Let me go back to you, Mr. Dow, and ask you a couple questions. One, what is the fee that you're asking for, and are the defense lawyers agreeing that their clients will pay for it? And then two, just tell me a little bit more about the settlement itself and your from the position of the guardian ad litem as to your belief about the settlement, its fairness, and whether it's in the best interest of ML. Thank you.
Sure. Question one, Mr. Ferguson and I emailed, it was either early or this morning or early afternoon, and we agreed on $3,500 as the ad litem fee. As to the settlement, so I do my own plaintiff's cases, and what I always do is look at the settlement and try to figure out what would a jury do. And of course, we never know the answer to that, but what's the likelihood that they could beat this at trial? It's always possible, but I think when you get up into this range, there's simply too much at risk to try to go roll the dice and get more. If she was continuing to have all sorts of medical problems, that's one issue. However, she's not. She's doing really well now. And as you heard, the case expenses were close to $120,000, which if they went to trial, could easily double. with all the experts coming to trial. So when I look at it that way, the likelihood of beating it and recouping those expenses and getting substantially more are in the less likely category. So I think it's an appropriate settlement. I think Mr. Weigel did a great job and earned his fee here. He continues to fight with Medicaid on that lien. And the plan there is whatever reduction he gets, the difference will go into the custodial bank account for McKinley Jamerical. And so that will only increase her net recovery, which right now is $384,000, almost $385,000. So it looks like a really good settlement to me, Your Honor. That was a long way of me telling you I think it's a good settlement.
Mostly, I don't want to open anything up, but how is ML doing?
She's doing great.
Okay. All right. I mean, it read pretty horrifically, the injury originally. So I felt now I was curious, really. That was nothing else more than you came before me in this bit of your case, and I just wanted to know the end of the story a bit and know how she is doing. But she's doing well?
Yes, she's doing great. She's making straight A's in school, and she's living a normal life as a normal child.
Okay, that's good. That's the good end of the story here. Thank you. My next thing to say, because the structured settlement world comes to our courthouse quite a bit, is just to let you know, ma'am, that I think structured settlements are a great tool and they really are a good place to put the money, and I'm going to approve this. But what happens a lot of times, and I'm sure that your lawyer, Ms. Thompson-Lloyd, and your daughter's lawyer will go over this with you, is these structured settlement companies, they are very aggressive and can be very aggressive in a few years, and they will start coming for you and trying to get you to settle. They do not oftentimes make good deals with the people they try to get. So just be prepared for that. We deal with this a lot in Travis County District Court. All the courts around the state do. So know that I believe what has been reached here is what's approved by this court is this structured settlement agreement, and understand that they can be at times, in this court's opinion, and I'm putting it on the record, a bit predatory with who they come after, and they do not make good interest deals a lot of times on your money. So I just want you to be prepared for that. Understand that a court in the future may not approve something, even if y'all agree to cash out and it sounds good in the minute. The reason they're wanting that is so they can earn money. They can earn interest on your money rather than you earn interest on your money. And so it really is interesting that you end up back at district court at some point, because that industry spends their time finding people like your daughter who are going to have a structured settlement in their name. And since we see so many of these, I just felt I needed to state that, how aggressive I believe those operations have become at finding people with structured settlements. I don't know how they find you, but I promise you they will find you. So talk to Mr. Weigel about it, have him tell you how to handle that, but understand that this is a good deal that helps you earn the most you can on your money and get a payout in a way that will hopefully help your daughter in the future, and that they don't come for no strings. They come because it helps them monetarily, and they will come for you starting when she probably turns 18. It's an amazing operations that they run. All right, that's my soapbox, Mr. Dow. And everybody else, I wanted to say it looks like good work here. Is there anything else anybody else wants to put on the record, since I put that on the record before I approve this and look for the final judgment, because I think we're at final judgment, and I should be able to sign a final judgment that ends the case. Anybody else want to say anything else?
Your Honor, if I may, on behalf of the defendants, I appreciate Mr. Dow and Mr. Weigel talking about the settlement, and I'm not fussing at them, but I think Mr. Dow was slightly off on the numbers. And I just want to make sure, since I've obtained the proceeds, I don't want it to have to go back and get new proceeds. And we're talking about a very, very tiny difference. And I just want to point that out. Mr. Dow was $25,000 off on what the settlement amount was. So, and we'll talk about it, and but wanted to point that out. And then in addition, I wanted to just point out that with regard to the Medicaid issue that I know Mr. Weigel is working very diligently on, we may well set aside a greater amount than the amount that Mr. Dow mentioned, because we don't know what the Medicaid sum is going to be, and it could be less and it could be more. So and I think that's consistent with what Mr. Weigel and I talked about. So again, I'm not fussing at anybody, but just wanted to put that out there, and happy to discuss now or after the hearing.
We don't need to discuss it on the record unless you just want to. Y'all can probably talk about that off the record after the hearing.
I do not. I just wanted to get it out there before we were done with the record. Thank you.
I have one point of clarification, Your Honor.
Go ahead.
I think that what Mr. Ferguson is referring to is the amount of the gross settlement proceeds when he said that it was off by 25,000, and that 25,000, Ken, is coming from the Easy Pawn defendants. So the aggregate gross proceeds are 1.1.
But okay, I apologize. My mistake there. So I was generally aware of that, but so thanks for clarifying that.
So I don't know that I have an order that is signed by everybody. Should I have an order that's signed by everybody, a proposed order?
We hadn't submitted one yet, Your Honor. I'm happy to send it to your submission before close of business today.
That works for me. With that understanding, at this time, the court's going to approve of this settlement, sign off on what the judgment, assuming it comports with form and everybody's signed it, when you send it to me, and we will get it filed. Thank you all so much. Good luck to Ms. Thompson Lloyd and your daughter, and you are all excused. Thank you.
Thanks, Your Honor.
Thank you, Your Honor.
Mhm.